Hi everyone, welcome to an hour with LawSikho. This is Ramanuj from iPleaders, and with me I have Rashmi Singh, today's guest, who's a technology lawyer working with a leading technology company as in-house counsel. Take Mahindra to be specific. And today's topic is technology contracts. What are the different kind of common technology contracts that lawyers frequently deal with in the leading technology companies and even otherwise? And we'll get a sense of that from Rashmi and we'll learn from her experiences. So Rashmi, welcome to an hour with LawSikho.
Hi, Ramanuj. Thank you. Thanks for inviting me for this session. And I'm looking forward to having a great session.
All right. So, let us jump into the topic straight today. I want to know from you, what kind of work do you have to do as a technology lawyer? You're an in-house counsel. There's
Yes.
technology lawyer is more of a tag that people put on people, lawyers specializing and working in technology domain. Uh, so, what's the sort of work that you have to do? Tell us about your, palette of work and how a day looks like on average.
Yes, Ramanuj.
Yes, Ramanuj.
So, yes, I'm an in house counsel for a technology company. So, the short form used is a technology lawyer. Now, my day to day work would definitely involve contracting, which is reviewing of contracts, all kind of contracts which my company works on, which I would be explaining in detail in this session. Reviewing of contracts and negotiating with the customers or the other party, whoever is the other party. Secondly, in order to review these contracts, I need to also connect internally with my internal stakeholders like my business team, my technical team, maybe the HR team, to understand what exact work we are doing. So it involves calls, calls happening all day to understand what is the scope of work, reviewing the document, post that negotiating on the document. This is the major part of work which we do in house. Apart from that, I also do certain advisory work for our internal functions, involving HR issues or maybe infrastructural issues. So all this is internal, what wherever company stakeholders need an advice, if they are stuck, if they have an issue. So we advise them from a legal perspective as to what the law is and how they can go ahead and sort out the issue. Apart from this, I we also do litigation support. So all the background work of any kind of litigation in which a company is involved is done by us in house. So more or less, this is what we do in a day.
So, when you are a technology lawyer and working as an in-house counsel in a leading technology company, what is the highlight of the job? What's the best part of, of your work? What do you enjoy the most?
I think what I enjoy the most is negotiating the contracts with the customers. Now, for me personally, I am working with a multinational company, so I get to negotiate the contracts with customers who are present in various different countries. So the mentality of the customers, the way they negotiate, the way they go through a deal, it's different from country to country and from region to region. So, for example, an American customer would have a different way of going through the negotiations as compared to a Japanese customer. So I think that's an enjoyable part of the work. You get to know how things happen in all these jurisdictions. Apart from that, there could be, there could be some advisory related things wherein you have to have a deep dive in that topic to get to know how exactly the law functions with respect to that topic. So that is another thing which I enjoy. And then you get to know how will the law function with respect to my company, with respect to an IT company. So that is something which is very interesting.
So, so in your day-to-day work, what are the biggest challenges? Something that you find hard to deal with, or something that somebody who's starting out will struggle with and have to learn and like and overcome. What are those challenges? Let's say there are top three challenges you face when you start working in this kind of a.
Okay. So when you ask me the top three challenges which I face or I have faced when I joined right as a fresher, right out of my college, so would be so first of all, when you pass out, you have learned the law, but you don't know how exactly it works, and upon that you are going into a specific industry. So the first challenge would be that you have to understand how the company works. Now if the company is a big company, it's a multinational company, or it has operations in all around the globe or in major continents, then the area is very vast. So first of all, the first challenge would be to understand how the company works, what kind of services the company is providing, what kind of people the company is dealing with. So I think that's the first challenge. It would take some time. It would take some time to understand that. Definitely you will talk to your peers, you would talk to your managers, your bosses, and understand how things work. So that is one thing. Secondly, I would say dealing with your internal stakeholders. Now, when you are working in the legal team, at the end of the day, you are helping the company in getting the business done or improving the business of the company. For that, you have to have a good connect with your business team, your sales people, your technical team. Now since this is IT industry, the core work is done by the technical team, the engineers. And these are the people who are they are not legal people. They would not understand how certain legal clauses work, or how a legal clause would have an impact on on the job which we are doing. Making them understand what the risk can be is it takes sometimes it takes efforts, because they are not aware of they cannot imagine the magnitude of a risk. So that is one challenging part of the work.
So how do you overcome these challenges? Like, let's take the last one, that you have a lot of colleagues who are important and very important part of the business. Sometimes even the management may not have understanding of legal issues or compliance problems. So how do you do it? Like, what role do you play as a lawyer there?
Uh, so to answer that question, um, what we so every company would have a certain set of process, wherein such risks in a contract would be identified. They would be highlighted to the management or the people, people at a higher level in the hierarchy of the company. Such risks would be highlighted to them. They would be told that if you go ahead with such a position, if you agree to such a position with the customer, then these are the uh, onerous things which could happen to us eventually if there is a litigation, or the project goes into, there is some kind of error in the project. So we highlight those risks to the management. We make them understand from a legal perspective this could happen, so we give them alternatives as to what all alternatives we can go in a particular position so as to avoid or reduce the risk. Then it is I mean there would be discussions happening. Then it's a team effort. There would be discussions happening, and then eventually we would come at a position and take that position to the customer.
Would you say it is a glamorous job to be a tech lawyer?
Glamorous. Maybe it depends from person to person. I would say it takes a lot of efforts, because as I said, the first point which I was mentioning, to understand the business, it takes a lot of efforts to do that. And yes, maybe some part of it you would enjoy when you are actually negotiating with the customer and speaking to them. So yes and no.
Okay, so now tell me about, what are the contracts, like if we say that there are like 10 contracts that you come across most often, what would those 10 contracts be?
Uh, so Ramanuj, first of all, I think let me start with a basic contract, which is a non-disclosure agreement, and it is a non-disclosure agreement is something which we come across on a day-to-day basis. We work on multiple non-disclosure agreements in any given point in a day. So a non-disclosure agreement can be entered with any party. It can be a customer of the company, it can be a partner, it can be a consultant. So and non-disclosure agreement is the starting of any discussion. So if you have to undertake any project, before that you want to discuss whether the deal will work out or how it will work out, you have to discuss your plans. So for that you will enter into a non-disclosure agreement. In that you would take care as to what, first you would see that who is disclosing the information. Is it you who is disclosing the information, or is it the other party, or is it mutual? Accordingly you would define what confidential information would mean. And then you would see what the governing law of the agreement is. And especially if it's a multinational company, then it would involve parties from all over the world. You would see the governing law, you would see what kind of information you're disclosing, you would see what all restrictions are there, what all compliances are there, how such information has to be stored, does it have to be destroyed after your work is over. So these are some of the important things which have to be taken care of.
So I am guessing that, in IT services companies, this would be a more frequent thing, while in product companies which are selling software, for them this may not be so relevant, right? Because when you are doing a IT services project, probably you need to get to know a lot of things about your client, about their business process, about who works with them. Like, I think the information sharing is massive when there's an IT project, because IT forms these days the backbone of everything. So I think
Yes.
this is something that is more relevant for services companies, would you say, rather than.
It is, yes, Ramanuj. What you're saying is correct. Given the scope, IT services are covering these days. Yes, it is very important for a service company to enter into non-disclosure agreements. But I think that even for product companies, it would be important, because even when a product company, let's say a situation where they want to license their product to a customer. Before that, maybe even they would want to enter into a non-disclosure agreement and then eventually decide whether they want to license the product or not. So I think there also it would be important. It's a basic agreement.
So it will be important for those companies where there's a long sales cycle, a lot of discussions happening, and a lot of
Yes.
information. Because a lot of time people just buy software off the shelf also. Like,
Yes.
I don't think if I buy, say Salesforce's software, or like, maybe Microsoft. There's no like Microsoft software you're buying. You don't do that. So can you tell us a little more about when there is these kind of agreements, so you have to enter into a non-disclosure agreement. Do you actually write down what specific information in a schedule or something? Like, how does, after the agreement, let's say, has, like, later on, if one has to figure out what information exactly is covered under the scope of this NDA, how is that determined in your experience?
So usually, it is not usual to write down exactly what you will be disclosing at the time when you're entering into the agreement. It would not. I think it would not be possible, because if, as let's say, the term of the NDA is for 1 year, then at the time, if you're entering into the NDA today, then today you wouldn't know what all would you be disclosing in 1 year. However, what you can do is that you can specify a purpose, that we are entering into the NDA for this purpose, and the information which will be disclosed through the NDA would include, among other things, so and so, so and so. You can list, maybe you
Is
can
it
give a generic.
possible? Okay, is
Uh,
it possible to create a schedule or something where you keep adding items or something like that?
yes, yes, of course, that is possible. That is possible.
Is
And
this?
Could you please repeat your question?
I'm asking if that is a common practice to keep a track of what information is being shared in an official manner under the contract.
Yes, that is a practice. And so what you would do is that as a compliance, you can mention in an NDA that whenever there is an exchange of information, whether it is an if it's a written exchange, then it's covered. Then there is no need to capture it. If however, if it's an oral exchange, then you may say that whenever there is an oral exchange, the both the parties or whoever is disclosing it or whoever is receiving the information will keep a note of it within a reasonable time, so that later on there we can keep a track of it.
Got it. So another thing that I see very often coming up in non-disclosure agreements, especially it is cross-border. Then what should be the jurisdiction for arbitration and courts? Which courts should have jurisdiction, which choice of law, and what should be the seat of arbitration and law of arbitration. So how do you deal with these things?
Yes, that's a concern. And actually, that's a concern in all the agreements, not only non-disclosure but other agreements as well. That's a major point of discussion. Now you have to see, so for example, if it's a multinational company, you would be having branches all over the world. So it becomes easier for you. So for example, if the other party is, let's say Malaysia. So, and you have a branch office there. So it's easier for you to agree to Malaysian laws. There is no issue in that. So it depends where the information is shared and what kind of information is being shared.
What
Governing law
if
can be.
it doesn't have a branch in that jurisdiction? Like say they are in Malaysia and they don't have presence in India, and we have presence in India but we don't have presence in Malaysia. How do you deal with such situations?
Then I would say, then we have to see that which party is disclosing the information, where is the, where it is likely the dispute will come. If I am receiving information from them and I am not actually sharing any information, and I am only receiving their information, then in that case, it's highly likely that a claim can come upon me if there is a breach. Then maybe I am not in a better position to say that I want to go with an Indian governing law. So that one thing has to be taken care of. Secondly, when you talk about the courts, the dispute resolution method, so it can be either arbitration or courts. These are the ones which you look after. I would say in an NDA we can simply agree to having courts as a dispute resolution method, because if you think of it, what could happen in an NDA? A data leak could happen, a confidentiality breach could happen. When it happens, what would be the first thing which you would do? You would go straight away to the court and ask for an injunction that please stop this party from using my confidential information. So I think we can safely go ahead with agreeing to courts as a dispute resolution option. Hello, Ramanuj, can you hear me? Hello. Hello, can you hear me, Ramanuj?
Yeah, Rashmi, we had lost you
Yes.
for a moment
Yes,
because
I
of
can.
fluctuation. Yeah, okay, we are back. All
Yes, I
right. So yeah. Sorry, you were like we got till the point you said there is sometimes a jurisdiction where there's where the which like what should be the place of contract. We understood that it should be when there is a risk on a certain party and not on the other, then you choose one over like the place where the most maximum risk is. The next point, if you can repeat.
Yes, the next point which I was saying was whether to go with courts or arbitration. So I think in an NDA, when there is what could be the breach in an NDA? The breach would be that your confidential information is leaked by the other party. So
Right.
the first thing which you would think of doing is that, running to the court and asking for an injunction order. That please, court, please ask the other party to stop using my information. So
Right.
I think we can easily go with courts as having a dispute as a dispute resolution option in NDAs.
Okay, but don't you think it can take a very long time to get the matter decided and so on? Like, isn't it a risk? Like, if you what if you have to claim a damage that claim damages under it eventually?
Yes, then if I want an injunction as in which is a nature or in nature of an emergency, then that's a first step that would happen eventually. When, yes, when I have to ask for damages, in that case also I think safely we can go with courts.
Really, because
Because
really people prefer arbitration as a more quick and effective resolution. Isn't that the case?
I would, yes, that it is quick and effective, but also it depends from jurisdiction to jurisdiction. Arbitration, I would say that arbitration would be preferred in other agreements, like when it is a service agreement, let's say, or any other agreement. I would like to have an arbitration clause in that agreement rather than rather than dispute resolution through courts.
Okay. And why is that? I mean, isn't like even if you go for arbitration, you can always there are usually interim solutions given. You can go to the court and ask for some sort of interim relief, even if you opt for arbitration. So why do you suggest courts?
Yes, yes, you can, of course, even if we have agreed to an arbitration position, we can definitely go to there is no restriction on you to go to the courts and seek an injunction. But so I am basically making a distinction in NDA and the other agreements. In NDA, I would like to simply keep it to courts as a resolution option. Other agreements, I can decide. Mostly, I would agree to arbitration or maybe sometimes courts, depending on the
Yeah.
jurisdiction.
What is special about NDAs that you prefer courts over arbitration?
So as I said that the major relief is having an injunction. Secondly, there is in an NDA as such there is no uh, it is it, so let me compare it with a service agreement. If there is a breach in a service agreement, a lot of aspects would be involved, wherein which are technical in nature, given the industry which I am working in. So maybe a court, when the court has to decide that, maybe a court would appoint an expert to decide that, which would take a lot of time. However, in an NDA, the only question is whether the data was leaked or not leaked. So that's why I'm saying that it can be okay to go with courts.
Okay, got it. So, what is the other most frequently encountered contract for you apart from NDA?
Apart from NDA, the major part of the contracting is a service agreement. So now, since IT industry is a service industry, so we enter into service agreements with our customers. Now, just before I move on to what has to be taken care of in a service agreement, just let me give you an example of what a work would be. So now, IT industry, information technology services, as the name suggests, is means providing information technology services to the customers. Now these customers can be, any industry. These customers can be in any industry. It can be banking industry, it can be a telecom service provider, it can be aerospace industry, it can be automotive industry. So whichever industry you think of in the world, everyone wants their IT services to be, everyone wants their systems to work through proper IT services. Now a simple example could be, okay, let me take a banking company. So a banking company would approach you and say that I want to, 90% of my banking activities would now happen online through a website and an app, and I want to develop a website for ABC. They would list out what all they require on their website, they would list out whatever they require on the app. For example, they would say, I want a chatbot on my website, so the customer can, pose some basic questions to that chatbot and the chatbot would answer itself. So the customer would come up with specifications, would tell you what all they require, and after that the IT company would provide, would enter into website development, software to be provided, software upgrades, management of the website. So this is basically what the IT company would do, and this would vary from sector to sector. Now, in order to do this, you would enter into a service agreement with the customer, wherein you will be a service provider and the customer will be your service receiver. The service agreement, it would start off, stating that what will be the scope of services and why the parties are entering into this agreement. And now the service agreement could, it can have any name. It can be named as a master service agreement or a framework agreement or an IT technology agreement. It could be anything. So now I would move on to what all, important clauses which you have to take care of in a service agreement. Okay, so let me start off with the representations and warranties clauses. So when you start off the agreement, so representations, as we know, that representations help determining the parties whether to enter into the agreement or not. They are, there are certain kind of things which you state at the time of entering into the agreement, acting on which the parties enter into the agreement. Warranties are again where you state how would you do the work. So for example, in an IT, in a technology agreement, generic representations and warranties would be that you would do work in a skillful, workmanlike and professional manner, that whatever services you provide would not infringe the intellectual property rights of any third parties. So these are some of the generic representations and warranties. And you definitely have to take care of what you are stating in the agreement, because if there is a misrepresentation or a breach of warranty, then the other party would have the right to claim damages from you. So it has to be taken care of specifically what all warranties you are providing, what all representations you are providing. That is one thing. um, then then you have to take care of the indemnity clause. So mostly all the customers would seek an indemnity from you. Indemnity, as we know, it is making good the loss of a party who has suffered a breach, who has suffered due to a breach. So now you have to take care as to specifically for what all things you are providing an indemnity to the customer. Now the customer would always want that, you provide them indemnity for each and everything, for even a minor breach which happens. So there, you have to negotiate with the customer and see that you provide specific indemnities to the customer. uh, in general, the indemnities which are provided are indemnities for breach of confidentiality, indemnity for breach, if any claims are there due to breach of intellectual property rights, then violation of law, if there are any claims if you have violated any law, then it could be due to breach of warranties, whatever warranties you've stated, and there is a claim due to such breach of such warranties. They could ask A customer would ask you indemnity for your negligence, your misconduct, or any misrepresentation. So these are the generic indemnities which are present in an IT contract.
So
And
do you try to limit the indemnity by at a specific amount or something? Does that work?
yes, yes. So now limiting your liability would be covered in a separate clause, which would be called as a limitation of liability clause. So I think it is very, very important to limit your liability under the agreement, because given the scope of work, given the work which you are doing for the company, there would be delays. It's not that there would be no breaches or no delays. When the chances there are good chances of a delay or breaches, it is very important to cap your liability under the contract. The value of the value to which your liability will be limited it's a negotiation point. So that would be negotiated based on what the price of the contract is, what how big is it, how what are the scope of services. That's a point of negotiation, but one thing which has to be taken care of, I think, is that it should be capped. And when you cap the liability, yes, indemnity you can say that whatever indemnities I am providing under the agreement will be capped in the it will be limited to this particular amount, whatever the amount is decided. So yes, that can be capped. A customer might not accept capping the indemnities, then again that has to be negotiated.
Okay. So, one major issue that I think that arises in these agreements is with respect to timely payment. So, how do you ensure that your company gets paid on a timely manner, and if what are the consequences of not getting paid on time? How does the contract take care?
Yes, that's correct. One of the major obligation of a customer in the contract would be that they pay us on time. That's apart from the other obligations of the customer. That is one of the major obligations. So for that, it is important to make your payment clause very strict, very specific. You can't leave it generic. You have to make it very specific. You have to link it to your now there could be payment milestones in the agreement, saying that if you do if the customer says that after first month till third month you have to do this amount of work in this manner, this quantity. After that, I will pay you. For example, I'll pay you within 30 days of when you raise the invoice. So specific the payment clause has to be made specific. You have to provide now there could be a situation where you have raised an invoice on the customer, and the customer can dispute the invoice. If the customer thinks that the invoice is not correct, or the amount stated is larger, it should have been lesser. So in that case, you have to specifically define in how the customer will dispute the invoice, what happens when the invoice is not disputed, what happens when it is disputed. All of that should be clearly identified. Secondly, you have an option of putting a late payment interest on the customer. Again, the quantum of late payment interest will have to be negotiated, but a payment interest could be put on a customer as a deterrent for the customer to make timely payments.
Okay. I think that's very important actually. If you don't have a late payment interest, then there is no interest in the client to pay you on time. They would want to delay it as much as possible because
Yes, 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 such a situation could happen.
okay. So apart from services agreement, so can you explain about master services agreements and when there are subordinate service agreements and all this? Like sometimes a company is providing services to like a group of companies, and there is this master services agreement. Can you explain how that works?
Yes, yes. So the situation which you are talking about, let's say, there could be a situation that there is a customer who has its affiliates in different countries. So let's say, for example, the customer's office is in the United States, but they have their branches or subsidiaries all over the region. Let's take, for example, a big automotive company, a big car manufacturer. So they will be based out of the US, but they will have their operations through their subsidiaries or branches in countries like India, Malaysia, Dubai, or any other country. So and if such a customer approaches you to provide a kind of services, for example, okay, let me take an example. Okay, so let's say the customer says that, I want to build a navigation system. I want to put a navigation system in my cars, and I want to take care of the software, the hardware, how the navigation system will work, and I want to also connect of the driver. The driver should have an app to connect with the navigation system, so something of that sort. And the customer would tell that this should be available in each and every country where I have my operations. So for that, that a preferred position will be to have a framework agreement, where it will be. So now master services agreement is only a term. uh, uh, Basically what is happening is that, as I said, you are providing services. The agreement can be called a master services agreement, a framework agreement, or anything. So you can enter into such an agreement wherein this company, as well as all the affiliates of the company, would be covered, and only through one agreement you would be providing services to to the company and all such affiliates in different countries. One thing which happens is that, now there would be certain peculiar things depending from jurisdiction to jurisdiction. For example, let's say Indonesia. So maybe in Indonesia there are certain specific laws which have to be taken care of, or any specific restrictions are there. So it can be in any country. So for that you can enter into, into it. It is commonly called as an adoption agreement. So you can enter into an adoption agreement wherein anything specific to that country will be stated, and it would be stated that the adoption agreement, the terms and conditions of the master services agreement are, mutatis mutandis, apply to the adoption agreement. Apart from this statement, you can cover the specific country specific requirements. So that is how it will work.
Right. So most of the time there's a form kind of, the adoption agreement is attached as a form in the schedule, right?
Yes, that's correct. You can, while you are entering into the master services agreement, you can, make an annexure A, say, and give a format of the adoption agreement saying that this is the format. And as and when there is a requirement of entering into an adoption agreement, this format can be followed by the parties.
Great. What are the other major agreements that you deal with on a day-to-day basis?
Yes. So apart from this, there are various partner agreements. So till now, I was talking about providing services to the customer, but there can be certain situations wherein I myself, as a company, I myself alone cannot give all such services. So I would need to partner with some other companies who, if such a company is a specialist in a particular software or in particular services. So I would partner with such a company, and it will be called as a partnership agreement or an alliance agreement. The name can be anything, a marketing agreement. So I and now there would now such an agreement would can have different models. So for example, if I am a service provider company, the other company can be a product company. I have to provide a certain set of services to a customer wherein I also require a specific product, but I don't have that product. So I will partner with such a product company through a partner agreement or an alliance agreement. Such an agreement would state that, that parties have identified certain set of customers, to which, party A will provide services and party B will provide product. So such kind of agreements are called alliance agreements. Now again, in such agreements, you have to define the scope as to what will party A do and what will party B do. What if party A is providing services, what kind of services are being provided? If party B is providing products, what kind of products will be provided? So all that has to be defined. Again, as I mentioned, in the indemnity clause, the limitation of liability clause, the governing law clause, these are some clauses which are the warranties and representations. These are some clauses which are generic for each and every agreement. So the same would have to be taken care in such agreements as well. Then one more subset of such partnership agreement is a reseller agreement. So basically the situation which I told you, that the customer expects me to provide certain services along with the product, but I don't have that product. So I would partner with a third partner with my partner, a company which has the product. So through in a reseller arrangement, what I would say is that I will pick up the product from the product company and just give it to the customer as is. My only job is to resell the product, because I want the deal to happen through me. So that is one aspect of a reseller arrangement. Another, then there could be a specific aspect wherein you further want to make changes to that product, add value to that product, and then give it to the customer. So this is one kind of agreement which is present. So all these form part of in general of a partnership agreement.
Right. So what would you say are the what other agreements do you deal with as
um yes. Apart from this, I would apart from this, there can be an end user license agreement. Now I work for a services company, so I might not come across that many end user license agreements, because as you know that end user agreement is signed by a party who is actually using your product, and the other party is the one who has made that product. So for example, any if you're using, let's say, Adobe Photoshop, so you have a click wrap agreement where you click I accept and then use the product. So those are basically end user license agreements. So there are certain circumstances where where we do make some products, or if it's a product company, they have made a product, so they will have their end user license agreement to be shared with the end customer, the person who's actually using the product. Again, in that agreement, you have to take care. The first thing which has to be taken care of is that what kind of rights are you giving to the customer? Is it right to use? Is it also a right to modify, also a right to sub license it further? All that has to be defined. Your intellectual property has to be defined. What are the intellectual property rights contained? And then what would be the remedies if there is a breach of the agreement? What would be the remedies? So all this has to be taken care of.
right?
Apart
Yeah.
Yeah, so maybe I could also. So these are the agreements. I was talking from the aspect of the customer, the partners, and the end users. There are certain, I also work on. You would also get to work on agreements at the organizational level, like when your company has branches at various places, then you would definitely not have the branch at your own property, and you would lease the property to have your office run. So there can be leasing agreements of the property, which you would have to work on. Again, there you have to take care of how much rent are you paying, how much security deposit are you paying, is the security deposit refundable, when is it refundable? So all these things have to be taken care of. And what
Basically,
happens
what are the real issues in a corporate lease? Like when you are, renting out office space for your company, I think there would be some significant concerns about business continuity, that you should not be. You make a significant investment in the interior decoration and creating a workplace out of just like a real estate. So, how do you protect those investments? What are the other major issues when you deal with corporate?
Yes. So when you do a lease agreement, then the aspect which you are talking about will be taken care in the, the furnishings and fixtures. It's the furnishing and fixtures aspect, so you would decide as to which party will be doing the furnishing and fixtures. And so for example, if you know that you are going to have your office in that place for a long amount of time, then maybe you can take the responsibility of the furniture and fixtures. But if you know that it is temporary in nature, and maybe a 2 year or 2.5 3 years period of, it has to be there for only such a period of time, then you can discuss with the landlord and have it, put the furnishings and fixtures responsibility on them. So again, it depends on, depends on how much time the office is
What
present for.
about premature terminations of such agreements? Like, how do you deal with or preclude the possibility of a premature termination?
We would, in case of termination, what I would look towards is that I should have a termination for convenience right in such an agreement, and try not to provide it to the landlord, because then I will be in a, I will be in a soup in that case. Then definitely there can be a termination for cause agreed. We can decide the In that case we can decide the notice period. Termination for cause, we can decide the events when the agreement can be terminated. So there, I think there we are safe, because we already know what the events are, so we can take care of it from a compliance perspective. uh, if at all there is a termination for convenience in such agreements, I would have like to have the right to myself. Worst case, if even the landlord has such a right, I would try to have a longer notice period, so that I can look for another space and have my business shift to such place, such alternate place.
All right. So what are the other agreements that you have to deal with? Apart,
Yes. Yes, apart from this, I think there are marketing agreements. So the companies do enter into marketing activities through, for which they hire a third party to do so, because again, it's not our core competency. So we will hire a third party service provider to do marketing for us. We would enter into a marketing agreement with such a third party. We will define what all marketing activities we want that party to undertake. Now such agreement can be for a definite purpose. Let's say, for example, the company is having an event. That event will only go on for a week, so you would only have a specific agreement. There can be a generic agreement also saying that for, for a year you have to take care of our marketing activities, including each and everything: marketing on social media, marketing, physically through posters and everything, and other methods. There again, you have to take care of what rights are you giving such a company, to display your logos, where all to display, how to display. So all that has to be taken care of.
okay, very interesting. So, are there any more agreements that you'd like to highlight, or this is more or less the entire palette of work?
This is I have mostly covered all the all the major types of agreements which are done. Maybe if I can cover one more, which is actually I missed it. I had to cover it with the MSA itself. It's a subcontract agreement. Now again, so basically it's more of a model wherein you have agreed to certain work to be provided to the customer. It's a big part of work which you have to do, but there is some part of it where you do not have a competency to do that work, or you are not a specialist in that part. So what you would do is that that particular part of the work you would subcontract to a third party. You would identify a third party that who is a specialist in that part of work and can do help you getting the complete work done. So you would subcontract that portion of work to the third party. For that, you will enter into a subcontract agreement with the third party. Normally it is with the consent of the customer, because the customer should know that who actually is doing the work. then in that case you have to take care that whatever obligations you have agreed with the customer are present in your contract with such a third party, so that there are no misses, because actually you are not doing the work, that third party is doing the work. And from a customer's perspective, customers always have it, make sure they have it in their in the agreement, that if we are hiring any such third parties, such subcontractors or agents, so the service provider will be liable for any breach. If such a third party commits any breach, uh, the company will be liable for it. The customer will come to the company, the customer will not go to the third party, customer will come to the company saying that this is the breach, you take care of it now. So that is one aspect.
Okay. So I think that was quite enlightening in terms of the different agreements we often deal with if you're working as a technology lawyer, especially from the perspective of a services company. Do you think there are some other agreements that product companies frequently deal with? If you can throw some light on that, too.
With respect to product companies, I think one will be an end user license agreement. I think that will be a main agreement which I have covered. Apart from that, again, I think more of it will be, in way of a partner. Otherwise, it will be a direct license. If it's a product company, it will be a direct license agreement with the customer, wherein they would be giving the right to, they would be giving a license to the customer to use such a product. That is one thing. Apart from that, I think it would cover the alliance or partner agreements which I was talking about, wherein such a product company would partner with another services company so as to increase their customer base. Because a customer would always want, apart from the product, always want services to be provided. So from that perspective, they might want to partner. uh, uh, yeah, I think that would be the.
Got it. So I have a question that has come from one of the viewers. The
Okay.
question is, Kapur HS is asking, can a young lawyer straight away jump into performing roles of a technology lawyer independently? Besides LLB, which other knowledge areas are must for the same? Like, okay, what would you say?
Okay. So I think it would be difficult, because I can tell you, because even I joined as a fresher. I joined the company as a fresher, and I mean, I'm telling you very frankly that um, I required, and even my peers who were there required substantial amount of time and to understand how the business works. And since we were working in a company, we had our seniors, we had our bosses to tell us how, as to how the company works, or how the customers work. Then
Yeah,
only
there was
eventually we
significant
started.
training time, you would be saying. Like, it took a while to train
Yes.
the operation. Yeah, right.
Yes, it took a while. So if you know that, you would get to know you would get to understand the business, or you have an understanding of the business, then very well you can go ahead. So I think the major aspect is to have an understanding of the field. Now there are, very technical things, very technical jargons, which I never knew it before I started working actually. So if you have that knowledge, you can very well go ahead and work towards it.
Great. So it's all about learning. If you have the right knowledge, right skills, it's not a problem, but otherwise you'll find it very challenging.
Yes, that's correct.
So he also asked, what are the areas that one should know? Like, apart from doing an LLB, what should he learn?
Okay. So I think the most, apart from, so yes, LLB as a degree, you have it. The most important thing is you should know the Contracts Act at the back of your hand. You should be very clear on your contractual concepts. That is one very important thing. Apart from that, maybe which I with respect to studying of law, it would be Contracts Act, it would be Companies Act. So all these intellectual property rights, to an extent, how assignments work, how how the transfer of IP works. That is one. These are the major things which have to be taken care of.
Fantastic. Okay, so just to for anybody who's interested, we do offer courses exactly on these areas, technology contracts, the contracts we discussed. We do offer courses on this, so you can check out our course on technology law, financial regulation of financial technologies, and even courses around technology contracts and all. And visit courses.lawsikho.com if you're interested. We do offer courses on the kind of things that we have been discussing. So, besides, I want to wrap up this session today. Thank you so much, Rashmi, for joining us and
Thank you.
sharing your experience and knowledge. And it's thank you for taking time off for our viewers, and on a Saturday afternoon, which is just time, of course. Thank you so much, and
Thank you,
we hope,
Ramanuj.
yes, we hope to have you again talking about some other areas of technology laws another day. And thank you everybody who watched. And we definitely hope to see you again. Tomorrow is Sunday. We don't have a session tomorrow, but Monday onwards, 8 to 9 p.m. Hope to see you here again. And do subscribe to the channel so that you don't miss any of the videos. Even if you can't watch some of them, you can always get notified and watch them later. So definitely subscribe and even click on the bell icon so that you get all the notifications. All right. Thank you, everybody. Have a great weekend. Bye.
Thanks, Ramanuj.